Weeramantry opened his mouth, he taught with authority, not as the scribes. So that's the gentleman we're dealing with. Indeed, truly one of Sri Lanka's proudest sons that we've ever had. So there's a lot to discuss. Sir, if you remember, we stopped at the law in crisis. And may I, before I pose the question to you, read a little bit from the foreword from the Right Honourable Lord Denning, then Master of Rolls, who writes a foreword to your Law in Crisis, Bridges of Understanding. We will show you these books in detail later. But His Lordship says, moral and spiritual values appear to be at a low ebb. The sanctions of religion have lost their force. Schools and teachers take much interest in social sciences. They explain how people behave. They seek to help the misfits, but they do not set forth the standards of the conduct. They do not tell people how to behave. The only discipline to do this is the discipline of the law. It is a law which teaches that men must not resort to violence to obtain their ends, that they must keep their promises, that they must not injure their neighbor, that they must act fairly and the like. The law covers the whole range of human behavior and says what men must do and must not do. This is the Right Honourable Lord Denning, then Master of Rolls, writing the foreword. Sir, what is this crisis in the law?
Well, the law in many countries is in crisis because there is a growing gap between the law and the people it should serve. The law is getting very often more and more remote from the people. And why is this? Partly because the law is expensive, too expensive for the average citizen. Partly because the law is too formalistic. Partly because the law is fraught with too much delay. Now, all these things operate against the administration of justice. And the more of these there are, the more is confidence in the courts lost. So we have got to build confidence in the law and in the legal system. And that can be done if we take note of our failings. And that's why I wrote this book, The Law in Crisis. Yeah. I wrote it not only for Sri Lanka, but for the world. Yeah.
In this, something that strikes one immediately upon reading it, not particularly, yes, there is certain changes that system must do, but you also speak of the lay indifference to the legal system, and that to all that goes with it is a result of many generations of neglect in communicating to the layman some understanding of the very groundwork of the legal systems under which he spends his life. Yeah. Do you want to elaborate a little bit on this?
Yes, the legal systems are very often a little removed from the people. They do not really take note of the real problems of people and their real difficulties. And there is this question of expense, which renders the law a little too expensive for the average citizen. And very often, especially in these formalistic systems, we find that take a poor landowner fighting a rich neighbor. The poor landowner, whose land has been encroached upon by the rich neighbor, has to take the rich neighbor to court. Now, the poor man cannot last too long. A couple of postponements and he has finished all the money he has. He has to sell his next crop. Then he has to sell his crops for the next 3 years. Then he has to mortgage his house and eventually to sell it. But it doesn't hurt the rich man at all. And the rich man wins the battle. So there's something wrong with this. And this is what was expounded in great detail by an American jurist, Roscoe Pound, who was one of the greatest American lawyers of the last century. He was once called upon to make an after-dinner speech at the American Bar Association. Right. This was around 1904, 1905. Right. It's a famous speech on causes of dissatisfaction with the administration of justice. Right. So anyway, when Roscoe Pound made this speech, the lawyers were expecting that he would compliment them on what excellent lawyers they were and so forth, as was usually done. Yes. But he came out with a litany of complaints against the American legal and judicial system. And he says justice was denied, justice was delayed, justice was too expensive, and so on. And he really set everybody thinking about what was wrong. And that led to a lot of thought in America as to whether their legal system was getting too formalistic and expensive. And that applies to so many countries. So in America, it even triggered off the growth of the sociological school of jurisprudence. So we must have similar sort of very, very searching inquiries on our legal system. And every country needs that, because every country has some gap between the needs of the citizen and the performance of the law.
Just very quickly before we leave you for a very short break, as you know, we are continuing our dialogue from last week, but there is a very interesting dialogue to come, that is on the people's judicial power, and are the people being beneficiaries of what is constitutionally theirs, and that's a discussion that is to follow, and several other areas. But before this, when we met, sir, you were very good. No wonder you were such a brilliant lecturer. Very good at telling stories, I'm sure. You recited this story that you quoted from Professor Julius Stoll, who had recited it before, of Mr. Millipede and Mr. Toad, which puts into perspective what we are trying to discuss now. Maybe we can leave you with that little story for a short break. Would you just like to?
Well, it so happened that when I was teaching at Monash, I was teaching a master's course in legal philosophy. Julius Stone, who was probably the outstanding legal philosopher of the last century, he used to come to Monash University every alternate year. And when I was teaching legal philosophy, he would do me the honor of coming and sitting with me, which was a tremendous thing for me, because when we were law students, he was a star glowing in the sky, and we were far beyond our reach. So here was Julius Stone sitting with me. And then I was talking about the process of judgment, because that is a very subject that needs detailed study. Many judges themselves do not know the processes by which they reach their decision. So Julius Stone, when I was talking about this, said, let me relate to you the story of Mr. Millipede and Mr. Toad, because Stone himself had written books on judicial reasoning. And what he said was, there was Mr. Millipede, who was a very nice gentleman, and Mr. Toad, who was a disagreeable fellow. And Mr. Millipede would like to go on his constitutional walk every morning. And unfortunately, it rained 3 days and 3 nights, and he couldn't do that. But on the 4th day, when the sun was shining brightly, he was very happy, and he went out for his constitutional walk. But Mr. Toad, who didn't like to see anybody happy, thought he would interrupt him and said, Mr. Millipede, can I ask you a question? One question. And Millipede, of course, said yes. And he said, Mr. Millipede, can you please explain to me how you coordinate the movement of your 1,000 legs? So Mr. Millipede, who had never thought about it before, sat down to think about it, and he could never walk again. So that is Stone's story about how judges often decide cases without knowing their own reasoning processes, because there may be 100 or 1,000 factors that operate subconsciously, unconsciously, and so on, to mold the judge's final decision. So there's got to be a lot of research into the process of judicial reasoning and the way in which all the different levers of choice which are before the judge are looked at by the judge, and he somehow chooses one rather than the other. It's a very complex process, and the judges need to know more about their own reasoning processes. And this is what Stone told his class.
Well, there you go with that little tale. We're going to a very quick break, and there's more to come in further segments of Checkmate, and we'll be back shortly. Hello and welcome back to Checkmate. As you know, we are on a continuation of our last week's program, and we are in the very honourable company of His Excellency Sri Lanka Bhimanya Justice Christopher Weeramantry, former judge of the Supreme Court, our youngest judge, and Vice President of the International Court of Justice. We now come, sir, to your interaction with the process in attempting to make a change with the system. And I am now looking at your book, A Call for National Reawakening, which I would say throws a lot of deep insight into what you've been attempting to do, particularly with the system. And may I quote a few paragraphs from it very quickly. One on the respect for law and order that you comment on. You seem to think that there is a lack of respect for law and order. Sri Lankan law and order situation seems to have reached at an all-time low. Respect for law and order has broken down at every level. From the humble police constable seeking to bring an offender to book for a minor violation, the way to the highest level, there is a denigration of the authority and rigor of the law and the legal process. And then once again you comment on bribery and corruption in the same tone. Do you want to comment a little bit on what you've seen and what made you write this?
Yes, I wrote this book 5 or 6 years ago, and I was observing that the confidence in the legal system was gradually weakening. And why was this? For several reasons. One was delay in cases. I have met people who have told me that their cases have gone on for 10 years, 15 years, 20 years, with so many postponements. I don't understand why so many postponements are necessary. Secondly, postponements are granted sometimes merely at the request of a lawyer who has some personal difficulty, and the case is postponed. But nevertheless, the poor client has to shoulder the expense. He has to pay the fees to the lawyer, and sometimes not just once, but over and over again, and he gets no service out of it. The ease with which postponements are permitted by the court, I think that needs to be reviewed, because cases are postponed far too often. I have met people who have told me that they have had their cases pending for 5 years, 10 years, and even 15 years. Now, there is no point in having a case 15 years, decided 15 years after you go into court, because you go to court for justice, and justice delayed is justice denied. So you want quick justice, otherwise you will be tempted to take the law into your own hands. Why should you go into a court of law? And you would try to get your remedy by fair means or foul. So these are all factors that are lessening confidence in the legal system. And wherever I go, I meet people who tell me, well, I was in court and there was a postponement. Was the case heard? No. Then at whose instance was it? The lawyer made an application. Did the judge inquire why the lawyer could not come? No, it was just allowed. So that's not good enough. And we need general judicial policy of hearing the case on the day stated. I have also heard that judges come late into court. Now, in our time, we were there on the dot, and not even 5 minutes delay between the time of scheduled commencement of proceedings and the arrival of the judge in court. Actually, not even 1 minute delay, but I hear now of great delays. I think that's not good and needs attention. And also, people come to court from great distances as a great sacrifice to themselves. They don't have common amenities where they are assembled and waiting the whole day. So that's all hardship and a denial of human rights. So all this needs to be gone into.
So on that very question, sir, can I bring you to another aspect that you deal with in extensio in what we discussed last week? The commentary on Bangalore Principles of Judicial Conduct. These are universal code of conduct for judges that His Excellency was the chairperson of the committee of which has been accepted by several countries now, which is to guide judges as a code of ethics. Now, in this, sir, you refer to some questions that took your consideration when you were formulating this. One of the questions was the statement in the preamble to the Bangalore draft, that's his draft, that the real source of judicial power is public acceptance of the moral authority and integrity of the judiciary. And that was questioned by some of the judges. It was argued that the real source was the Constitution, and that too great an emphasis on the ultimate dependence of the judicial power upon general acceptance could in some circumstances even be dangerous. Now, with that, I'd just like to comment on Article 3 and 4 of our Constitution. As you know, sovereignty of the people is inalienable. Then you and several others recently have propounded this public trust doctrine, that these powers are held in trust for the people. Therefore, the citizen is the ultimate repository of this power, and he gives this judicial power, whilst giving to Parliament the legislative powers and the executive the other powers, judicial power to a system of judiciary, lawyers and judges and the system. Now, sir, how do we address this question? Yes, if it is constitutional, and if the power lies with the people, and if the judiciary then is the temporary custodian of this power, legislatively, if the people don't like they can elect them out because the legislature is elected. Similar with the executive, they can vote them out. But the judiciary is selected. What does the citizen whose judicial rights are being exercised by the judiciary do in such a situation where the citizen feels that he is not getting the benefit as the ultimate beneficiary of his judicial power? What can a citizen do?
Well, the citizen really, in that kind of situation you described, is powerless. But all this arises because there is insufficient general education given to the public about their judicial system. I think we need to step up the level of education in relation to fundamental rights of the people. In fact, I believe that peace education should be a compulsory subject in all schools, and that education regarding human rights is part of that. And there must be a deep consciousness on the part of the public of their rights and their expectations from the court. And also there has got to be a tremendous respect for the judiciary. That is something the judiciary itself has got to cultivate, because it is something on which the prestige of the judiciary depends. The judiciary needs and functions on the basis of public respect, not on the basis of constitutional guarantees. Constitutional guarantees exist on paper, but the real authority of the judge comes from his moral authority and the fact that the public respects the judicial institution and respects the incorruptibility of the judges. Now that is the basis on which the judges hold their office. And that is why I feel that this code of judicial conduct, which we worked out for the judiciary of the world, should be more widely known and more widely followed, because it deals with so many aspects of the denigration of the authority of judges. And there has got to be total public respect for the judicial institution, going back, as I said, 3,500 years to the Pharaoh's edict to his Chief Justice, that justice is the central pillar on which the whole administration rests.
Yes.
If justice fails, well, administration breaks down.
Yes. But that's a very question that I'd like to bring you to, sir, if I may. The Bangalore Code that we discussed last week, the committee of which you shared, unfortunately we don't have time to go into all the areas that you've discussed in it, but it's very good reading for anyone, and it's available from the Weeramantry Center. We will discuss it later on. But just some of the areas that you have described, such as independence, integrity, competence, impartiality. Perhaps you'd like to comment a little bit on, maybe not all the areas, but a little bit on some of these areas that concern your committee when you were drawing this up.
Well, firstly, competence. Now, judges have got to be elected, not on favoritism or anything of that sort, but on sheer competence. And competence should be decided on the basis of the judge's training and the regard in which he is held in the circle of lawyers to which he belongs. But I start with saying that judicial education has got to be stepped up. And education means education not merely in the black letter of the law, but in the sociology of law, in the philosophy of law, in comparative law, in international law. That is what gives judges a special background to be able to be in the vanguard of developing the law. So that judicial training is necessary, then continuing judicial training is necessary. All that in regard to the judge's ability. Then in regard to the judge's character, there has got to be, of course, a very rigid standard of insistence on the highest standards of integrity. And there should be no connections which make the judge want to tilt this way or that way in the process of judgment. That has been stressed by all the religions, from the ancient Hindu law, Islamic law, Christianity, Judaism.
Which you've quoted.
I've quoted profusely.
We discussed that last week.
All of that is there. And integrity is one of the absolute essentials of the judicial office. Then there is also the need for the judges to conduct themselves in a dignified manner. There should not be shouting at witnesses, scolding of lawyers, intimidation of people, nor should the judge be browbeaten by senior lawyers who appear before him. Sometimes when the judge is far junior to the senior lawyer, he may show some respect or subservience to the lawyer. That should not be, because the judge is the primary person in his court. So there are lots of respects in which we have to give attention to this, and particularly total integrity, because justice must not only be done, but must be absolutely and clearly seen to be done.
Yes.
And there should not be the slightest whisper of a suggestion that there was corruption anywhere.
Yes. On that note, sir, can I quickly take you perhaps to a related area? Unfortunately, I cannot comment from this document because this is not published yet, which you've sent to Interconference, but just some thoughts that come out of it. This is a very novel approach that I must say not many people think of that aspect. You discussed that customary legal systems throughout ages have concentrated and given due attention to the rights of children and generations still unborn. But you make a distinction in contrast to modern legal systems where you say we concentrate more on the present and we don't look at the generations unborn. Now, sir, this is very much, as I told you when we met, the ethos of checkmate. Here is a new future Sri Lanka has been given. Here is an end to an era of violence, the chance to build a new country. And the future generations watching out there, future judges aspiring to be like you. This is a concept that needs discussion. You argue that in the legal systems we concentrate on now, very little attention, if at all, is given to that future unborn generations, but we concentrate more on the present. Do you want to elaborate a little bit?
Well, I think it's a great gap in legal systems, not merely in Sri Lanka, but across the world, that they do not have provision for the protection of the rights of the unborn. Now, we are deciding cases, we are deciding matters of law and equity and so forth, as though we are the only persons whom these decisions affect. But these decisions affect generations yet to come, because some of the matters that are involved damage the rights of generations to come. For example, nuclear pollution of the atmosphere and the environment lasts for 25,000 years and more. And we are inflicting that without carrying a rap. This present generation is inflicting this damage on generations yet to come for 1,000 generations. And our law permits that. Why? Because future generations cannot appear in the court of law, therefore they are voiceless, and therefore they are rightless. Now, that is an absurdity, and I think that many legal systems suffer from this. I have addressed a very strong note to the Conference of Global Judges taking place shortly, saying that this is a huge gap in legal systems which we need to remedy urgently, because just because an interest cannot be represented by a physical person in court, that interest must not be totally neglected as if it did not exist. And this is a fault of legal systems and lawyers, because they are thinking of the present and not the long-term future. They are thinking of the individual and not society. They are thinking of rights and not thinking of duties. All this is wrong. And the whole legal system in many countries is loaded with false values. I believe this arose particularly after the Industrial Revolution. It has gone on now for a few centuries, but it's time for us to change it.
Well, we got to go to a very short break with that very novel concept which we're going to come back and discuss in our last segment of Checkmate. Unfortunately, we could have discussed for hours and hours with His Excellency, but we are going to come back after a short break. But before I go, may I remind those viewers to keep writing into us. We value your comments very much. The production team goes into meticulous care to reply whatever emails that we get. You'll find the email address and our Facebook page appearing at the bottom of the screen. Particularly our viewers overseas, thank you very much for your contributions. You have made Checkmate one of the most sought after programs, and that's all thanks to you and the guests that have appeared on Checkmate. So thank you very much. Keep the dialogue alive. Remember, we're trying to build a better country, and it's your interaction that's needed, and that's the Checkmate ethos. We go to a short break. We'll be back with you in the company of His Excellency Justice Christopher Weeramantry soon. Hello and welcome back. We are in the company of His Excellency Sri Lanka Bhimania Justice Christopher Weeramantry on tonight's checkmate, and we go into our last segment of tonight's program. Sir, just a very quick comment, if I may, on some of your thoughts. You seem to have traversed an area where you come out with this thought that looking back on history, legal systems, there must have been something wrong in the scale of values which permitted judges and lawyers to endorse slavery, legalize the plunder of conquered territories, legitimize the appropriation of lands possessed by groups since time immemorial, and you go on. And to condemn people for a lifetime of servitude in Australia for stealing a loaf of bread. If anyone can prevent such abuses, it is the legal profession and the judiciary, who need to see the broader vistas of human future rather than confine their vision to the law in books. Is it that bad?
No, lawyers and judges have always, down the centuries, been confining themselves too closely to the law within the covers of the law books. But the law as it operates in the field is something they do not give their attention to adequately. Now, it is true that if a man steals a loaf of bread, well, he needs to be punished. But at the same time, if that man was starving and was not able to get a morsel anywhere, and he found a loaf of bread and he stole it, is that a reason for condemning him to penal servitude in Australia for the rest of his life? Now, those are factors that judges should have given their thought to, much more than they did in centuries past. So there are so many instances like that. For example, even recently apartheid, which was endorsed by the legal system. And today, even nuclear weapons, which are so obviously wrong and a crime against humanity, are permitted, are looked upon as legal by lawyers. I think there's something wrong there. And may I say, just to show how absurd it is, in the 19th century, at the close of the 19th century, when the dum-dum bullet was invented, which exploded when it entered the human body, all the nations of the world, who called themselves at that time the civilized nations, they met together and said that the dum-dum bullet was too cruel to be used in warfare among civilized nations. But the same legal system which condemns the dum-dum bullet says that the nuclear weapon is all right. So there's something quite absurd there, which lawyers ought to be able to give their attention to. It is so obvious to the outsider, but it does not seem to strike lawyers and judges. So I say that lawyers and judges should be able to step outwards and look at the legal systems or what they are doing in a more, shall we say, in a wider perspective than they usually do.
Yeah, so on that note, can I just take you to, I think, one of the highlights of your career, where you spoke of the so-called developed world. At the U.S. bicentennial celebrations, at that time there were three worlds: the first world and the communist world or second world, and the third world, which was what you were said to belong to. And you were invited to speak, and in that particular order, first, second and third. But I hear that you did quite well, and you had much more information that people expected. You want to comment a little bit on that highlight? I mean, that would have been a wonderful opportunity.
Yeah, it was a great opportunity for me, and this was part of the official celebrations of the American bicentennial. So there was a vast audience. And speaking for the third world, I drew attention to the richness of third world cultures, which many in the Western world had never heard of, and to the potential of the third world, and to the fact that the third world had wonderfully developed legal systems and so forth. And so because I was the third world, I spoke third after the first world and the second world. But after I spoke, the jurists who spoke of the first world and the second world came up to me and said that many of the matters I referred to had never come to their attention before. So that is our fault. We of the third world are not propagating this information. We are not spreading it widely enough. And we have got to show the rest of the world that we have wonderfully rich traditions which we have inherited, and that these are capable of fertilizing world civilization as they have done in the past. So this is some of the work that we need to do in the future, and that gave me a great opportunity to examine both the strengths and the shortcomings of the third world, because I had to do a lot of research for that presentation. So I feel that one of our faults is that we do not build sufficiently on the richness of our cultures and traditions. And the other is that we are missing, terribly missing, a lot of opportunities that are coming to us to build on that past achievement something which is of lasting value to the entire world.
Well, you seem to be one person out of the several who are actually attempting to make a difference. Just for the sake of those viewers who may have missed us last week, so you've been the youngest judge of our Supreme Court, the only Sri Lankan judge to serve in the International Court of Justice, Vice President. You hold several degrees, honorary degrees. You've won all these awards and honors. You published numerous books. And with all that, after that extensive career, you've decided to come back and do your little bit for this country, and we are so grateful for that. There is a Weeramantry International Center for Peace and Research now, where I know that there are several overseas students also there now. Do you want to talk to us a little bit of this, your concept of using international law as an instrument of building cross-cultural understanding and peace?
Yeah, I found that there is a great gap in peace education all over the world, including Sri Lanka, and I have urged very strongly that peace education should be a compulsory subject. Unfortunately, that has not attracted sufficient attention. But I think peace studies have got to be taught in schools. So my center rests on three pillars: peace education, cross-cultural understanding, and the use of international law as an instrument of peace. And what we do is we get together students from all parts of the country, and we give them week-long seminars on this, which really correct a lot of misunderstandings. For example, when students from Jaffna and students from Mathura get together, initially there is a lot of reluctance even to enter into dialogue. And what we do is we see to it that they get together and that they share accommodation, etc. And after a day or two, we find them becoming closer friends. And as they part at the end of the week, they say we are friends for life. Then another aspect is cross-cultural education. What we do is every morning we begin with extracts from the scriptures of the four religions of Sri Lanka. And the Bhagavad Gita, the Dhammapada, the Quran, the Bible are given to the students, and they have to select passages from them which they would like to read aloud and discuss among themselves. And this builds a greater understanding of each other's cultures. And every day begins that way. And by the end of 1 hour of discussion, we see that they're all getting very interested in each other's cultures. And thirdly, international law is an instrument of peace. This is something I have introduced out of my experience, but I fear that in most countries, international law is still thought to be a very specialized discipline meant only for the experts. I think that international law, the basic elements of it, can be taught in schools. And I have gone into schools in Sri Lanka, in Australia, in England, in America, and talked to 13 and 14-year-olds about the basic principles of international law, which are all principles of good living and common sense. And they are thrilled to know that there are such principles which the world recognizes, because they get disillusioned later with the cynicism of the world. But at that stage, they're absolutely thrilled to know that these ideas have gained universal acceptance. And
just on that note, several commentators on your commentaries, on what you've written and what you've spoken, comment on this particular aspect. What makes it so interesting when you propound international law, they say, it appears that you draw a lot from your background, your surroundings, Sri Lanka, Asia, and the history. And this is encompassed in several commentaries. One, where I'm reading from, which is about your childhood memories, when the commentators say that you compared your memories as a child, where you accompanied your parents on your visits to historic cities, Anuradhapura, Polonnaruwa, and the sites of those huge reservoirs. And then faced with similar problems, you ask in a subsequent case, which I'm going to refer to, asks how did our king set about damming the rivers and the waterways without damaging the environment too much, and also improving the welfare of the land of its people. So you seem to somehow find this lovely way of coupling your international law with lessons that you draw out of our philosophy and our history. Another one that I'd like to bring your attention to, this principle of trusteeship that you speak in Tread on the Earth Lightly, and may I say, on this passing note, sir, that you are one person that has been an inspiration to several, who has, as you went higher, who has certainly left a mark and treaded the earth very lightly. And that is indeed a privilege to associate a person of your caliber. But you seem to draw inspiration a lot from our values. You want to comment a little bit on it?
Yes, Sri Lanka is very rich in tradition, very rich in great values concerning human society and the human future. And we can draw on it because what I feel is that we have a tradition which very few countries can match. We have, for example, as Arthur Clarke himself has said, the foremost irrigation system seen on the face of the planet. 2,000 years ago, we have the biggest buildings of the ancient world next to the pyramids of Egypt. We had ambassadors in the courts of Rome and China. Even countries like England and so on were distant provinces of the Roman Empire. We had monastic universities which attracted thousands of students from Arabia to China. We recorded the Buddhist scriptures in an enormous compilation in the 1st century, which is one of the biggest compilations of the ancient world, far outstripping Justinian's codification, anything of that sort. So we have done some wonderful things in the past, and we radiated peace throughout the region. Our civilization was a center from which, I suppose, engineering knowledge, architectural knowledge, religious knowledge, knowledge about peace radiated into the entire region. We have done it before, we can do it again. We have the necessary inspiration, we have the necessary traditions, we have the necessary ability, but we must put our own house in order. Yes. And we must need to understand how the culture and the background and the problems and the vicissitudes and all the difficulties of all our neighbors. So peace education is vital. Yes. And we have got to generate that in a big way. And if we can do so, I think we can rise resplendent to a wonderful future.
Yes. I'm going to give, as we all do to all our guests, because our guests are selected for this very purpose, that Sri Lanka Rupawahini would like to archive and keep for our future generations what you have experienced, the problems that you've had to grapple with, and what you have to share with those future Sri Lankans aspiring to be what our guests are. I'm going to come to that in a few minutes. I'm going to give you 2-3 minutes to speak to the future Sri Lankan watching out there. But before that, can I just go back to that concept, the very philosophy that you just propounded, of this principle of trusteeship that you speak of in several of your cases, that these powers are not the judicial powers or executive or whatever they are not absolute and given to people who are there for a time being, but they belong to the people. I'm quoting once again your references to our history in one of your reported cases. Here in the East, only a secondary role is played, and as pointed out by Arahat Mahinda, when he surprised King Devanampiyathis in the middle of his hunt with the following words: "O great king, the birds of the air and the beasts have as equal right to life and live and move about in any part of the land as thou. The land belongs to the people and all living beings. Thou art only the guardian of it." Do you want to comment a little?
Yeah, I think that applies in all walks of life and to all kinds of property and to culture as well. We are not the owners of anything. We only hold it for the benefit of those who are to come after us. Of course, we must enjoy it, as Buddhism says, as the bee sucks honey from the flower without damaging the flower. We enjoy it, but not damaging it, so that it can still remain for the benefit of others. So we hold that, whatever the assets we have in trusteeship for those who are to use it hereafter. We cannot pollute the environment, damage the atmosphere and so on in a manner that affects future generations. And we have got to remember that, as African tradition tells us, Archbishop Tutu says this in many of his sermons, that the human family is threefold: past, present and future. We think only of ourselves. Only those who are alive here and now are what the legal systems think about. But we have to think about past and present and future. And any decision that does not consider all those three is a lopsided decision. Now, what has happened is very often those who hold power in this world, whether economic or political or otherwise, can think only in terms of short-term perspectives, because the balance sheet for next year must be good. There must be votes in that the next election 2 years ahead. So short-term perspectives dominate all thinking in the places where power resides. We have got to correct that. And long-term thinking has got to take its place. And the World Future Council in Germany, of which I am a founding member, is based on that philosophy that in the old days, there was the village elder and the wise man of the tribe, people like that who would give the community the long-term perspective without having to depend on the next election. So they gave that long-term perspective. That is lacking in the world today. And I think people who can take that long-term view should impart that as much as they can, rather than permitting short-term perspectives to cloud the human future. That's what's happening.
Yes. Sir, I do not know how to thank you, but before we go to the end of what has been a wonderful 2 episodes of Checkmate and not one, as I said, we found that one was not enough to encapsulate all of this, and I don't know how much justice we've done to all the work that you've enjoyed and accomplished in a lifetime. But this is our ethos at Checkmate, where you are brought here, you're invited here, you're gracious enough to come, and this is your moment to share your thoughts on that future Sri Lankan watching. Perhaps another Justice Christopher Weeramantry in the years to come, when you and I may not be around to see that. But this will be archived and kept for those future generations to watch, learn, emulate, aspire to be, so that one day they will make a great country, take us back to the pristine glory that we enjoyed. What is it that you, the Christopher Weeramantry of Sri Lanka, have to tell that future Sri Lankan watching?
You mean to young people?
Yes.
Well, I think all young people of Sri Lanka ought to feel that they have a very rich tradition which they can build on. They have great opportunities. We have a country that has come out of three decades of warfare, and we are building a peace over the ashes of conflict. This is a wonderful opportunity to show the world how the goodwill and the fellow feeling that used to exist among all communities in the country can be built, rebuilt, and improved in the years to come. How the message of peace, scholarship, understanding can be spread. How we are the, shall we say, can be a torch bearers of the lights of, shall we say, learning and peace and religion and all the values on which human society depends. We are uniquely placed to spread that in the world, and young people should rise to this great opportunity and build a tremendous structure over the ashes of war and make Sri Lanka an example to the rest of the world. You have the opportunity, you have the ability, you have the resources, you need the energy and the, shall we say, the determination to do it, and I'm sure you can do it again. Thank you.
Yes. Sir, on behalf of Rupawahini, our production team, indeed the entire country, we must thank you for making Sri Lanka truly proud of all your accomplishments. You've sat very patiently with us over these hours and shared your thoughts with us. Thank you for honoring us with your presence. We are very proud of you. Indeed, I'm sure the whole country is proud of you. And the humility with which you carry all that in your stride is the greatest moment for one to watch and emulate and learn from. We are very, very grateful, honored and privileged by your presence with us. Thank you very much, sir. May we at Sri Lanka Rupawahini and our production team at Checkmate wish you all the very best and several more years of your service to this great nation that you and I love so much. Thank you, sir.
Thank you very much, Krishna. It's been a great pleasure. Thank you.
So, together with the production team of Checkmate, we once again bid you good night. And we do so with the hope of seeing you again on another one of our programs in the not too distant future. And I leave you with these words from H.W. Longfellow. Heights by great men reached and kept were not attained by sudden flight, for they, whilst their companions slept, were toiling upwards in the night. Future Sri Lanka, young Sri Lanka, we'll see you again.